Good morning. Good morning, everybody. Can you hear me? All right. A real good morning. Welcome, everyone, to the Board of Behavioral Sciences, the Policy and Advocacy Committee meeting. So today is October 11, 2019, and the time now is 8:36. So first agenda item is I'll have Kim to call roll.
Christina Wong,
Here.
Max Disposti,
Here.
Betty Conley.
Here.
We have a quorum.
Thank you very much. And so for this time, I would like to have our board members, staff, and the audience to introduce themselves. So for the audience, your introduction is voluntary, and if you choose to do so, please come up, say your name, and also the organization that you represent. So we'll start with Kim.
Kim Madsen, Executive Officer for the Board of Behavioral Sciences.
Christina Wong, LCSW member.
Sabina Knight, Legal Counsel.
Max Disposti, public member, BBS. Why is not board? Oh, it was off. Max Disposti, BBS board member.
Ooh.
Public member.
Betty Connolly, LEP member.
Roseanne Helms, Legislative Analyst for the Board.
Christy Berger, Regulatory Analyst for the Board.
Steve Sodergren, Assistant Executive Officer for the Board.
So the first mic on my left is open. So if you can come up and maybe, Becca, you can just pull the chair out. Yeah.
Okay.
Thank you so much.
There you go. Rebecca Gonzalez, National Association of Social Workers, California chapter.
Thank you.
Janley Wong, NSW.
Welcome.
Jacqueline Escobar, Clinical Society for Social Work.
Welcome.
Kristen Roscoe, Kempt.
Welcome on board. Thank you so much. So now we will move to our second agenda item is the approval of August 2 minutes. We don't have the minutes, right? So we need to take that, out of our agenda item. So we will move on to the discussion. So the first one is the proposed legislation, the technical changes for 2020, and I believe it's Roseanne.
That's me.
Thank you.
So every year we look at some technical changes that have been brought to our attention over the past year. That's usually just cleanup or minor items that aren't big enough to justify their own bill. We can either put it in this year's omnibus bill, or possibly, if it's a little bit too substantive, the sunset bill this year, or perhaps another bill that's related. So we have several items. The first one has to do with professional corporations. There are 3 sections in the law, one for LMFTs, one for LCSWs, and LPCC corporations. It says that the corporations are authorized to render professional services as long as the corporation and its shareholders, officers, directors, employees, are specified license holders and are in compliance with the Moscone-Knox Professional Corporation Act. And the sections go on in a little bit more detail in our specific licensing acts. They list which license types may be officers, directors, or employees rendering professional services. However, the list is already in Section 13401.5 of the Corporations Code, and occasionally the legislature changes the list to add other professions. So, for example, recently the legislature added midwives and naturopathic doctors to the list, and they have not been updated in our Business and Professions Code. So in order to, rather than try to keep that list current every year, the staff recommends striking the list of professions in our code and just saying that the officers, directors, or professional employees or shareholders must be in compliance with the Moscone-Knox Professional Corporations Act. So that way we don't have incorrect or duplicative language.
So Sabrina, so should we actually do each vote, or do you want to do it as a packet? I mean, there are 8 of them.
Right. I think you should take them one at a time and then wait to do your motion.
Okay, so we should probably pause and
Yeah.
Yeah, I think you should discuss
We
each
can discuss it
and then
each.
move on. And then you can have a motion that
so
incorporates them all.
one motion, but
Yeah.
we should,
Yeah.
yeah, okay, that's fine. So board members, any discussion, any opinion? I think this is great. Make it simple. Yeah.
I agree. And Moscone Knox does change often, and they've been expanding those license types throughout the years. So we can't keep up with that.
No. You can't just go up for legislative change every time they add a title. So this is a good addition. Okay, public comments in regarding of this amendments? No? Okay, wonderful. So let's move on to the number 2.
Okay, number 2 is just a really minor correction. 4980.43.3 it contains a numbering error for subdivision C. There's 2 criteria that should be listed as A and B instead of 1 and 2. It causes the section to read incorrectly. So we're just recommending to renumber the contents of subdivision C in order to correct the error.
I don't think anybody would oppose the renumbering.
Super technical on that one.
Right. Board members? Okay, good to go. And public comments? No objection. Wonderful. Number 3.
All right. The next is there are the 3 sections, 4980.43.2, 496.23.1, and 499.46.2. These sections define 1 hour of direct supervisor contact as a specified amount of face-to-face contact between one supervisor and their supervisees. And so we've had some questions about this occasionally in licensing. The intent of the term face-to-face contact is to actually mean in-person contact. And it's implied later on in law when we talk about video conferencing and that video conferencing is permitted in an exempt setting. So it's sort of an indirect implication, but we get questions about the meaning of face-to-face. And so staff believes it would be helpful to clarify that face-to-face contact means in person. So we would propose to amend the definition of 1 hour of direct supervisor contact in those sections to specify that it is required to be in-person face-to-face contact.
I think that's add a lot of clarity, to, I guess that, face to face, I think is crystal clear and it's in person, so. But I do have a question. So I was looking at the number, of the law. Now, so does LPCC have the similar section? Because
Yeah, it's 4999.46.2 on page. Let me see if I can get to it really quick.
So that's page 26. So I thought that belonged to the social workers. So that's okay.
Yeah, social workers are 4996.
Yeah, they're the 4996.23.1.
Okay.
Yeah.
All right. So the 3, those 3 amendments covered all 3 license types?
Yes, they do.
Very good. Thank you. Board members, question? Good?
No, that should be good.
That should be good, huh? Public comments? Like that, huh? Okay, good. Number 4, Roseanne.
Okay, the next item is something that was suggested by the Senate Business and Professions Committee this past year while we were running AB 630. That was the bill that amends the law to require unlicensed or unregistered therapists in exempt settings to provide their clients with a notice about where to file a complaint, since they are not necessarily required to be licensed by the board. And so that bill was just signed by the governor. It will become law January 1st, so we'll be working on outreach for that. But it's in its review of the bill, the Senate Business and Professions Committee made a suggestion, and it was too late without holding the bill for the year to take it back to the board. But they suggested that we put in some language for the people that are working in an exempt setting that are not licensed and registered, that if somebody's unsure about if their therapist is licensed or registered with the board or not, that there be some language in there that says the board receives and responds to complaints about licensees, and if you're not sure, to go ahead and contact the board to see, so that the board can look it up and see if we can find them or not in our system. So there's some proposed language there for you to consider. And so if you approved it, we would amend the required notice to include that language.
So the only thing I'm thinking about is like so in the exempt setting law, so we are using therapist as the term.
Mhm.
Okay. So, then I would really recommend, the second line, because you use, in the language, it use, psychotherapist and therapist, interchangeably. And so I want to, I think it would be good to be consistent, to maybe take the cycle out of it, take the cycle out of the therapist. Oh my God. Sorry, bad joke. Bad joke. And it's on the record, so that's too bad. Yeah, so. Sorry. I know, I always do. So, no, this is a bad joke. All right. So, no, it's not meant to be a joke, but it's just really funny.
Yeah.
So, so we would take, we'll be consistent, be the psychotherapist,
And therapist.
and just the therapist itself. So, would that work? Yes.
Okay, so you would say the board receives and responds to complaints regarding services provided by licensed or registered just therapists.
Right, just the therapist.
Yeah.
Yes, Kim, and then.
So that might just have the connotation that it's just for marriage and family therapists. So what's the language that is currently in there? Is it psychotherapist?
The language in the current notice to clients says that this particular officer, unit, or agency receives and responds to complaints regarding the practice of psychotherapy by any unlicensed or unregistered counselor providing services at.
So maybe we just take that same language and mirror it for consistency.
Just for consistency.
Yeah, I
Okay.
was going to suggest using the word counselor since it's in the prior paragraph.
So it will be counselor for the second line, and then the counselor, let's see, I think there's.
For the third line too.
For the other, yeah.
Yeah, the second line and the third line, we would change psychotherapists in the second line to counselors.
Yes.
And the third line, we would
The
change
third
therapist to counselor.
Right.
Is that-
Yeah, I think just using the consistent language would be good. Much clearer to the public, and it's
Right.
confusing.
I have a question for Kim. Kim, do you feel like I can just imagine everybody calling the 916 number just to verify everyone else's license?
Right.
We don't have a way on the website to also do that, right?
Yeah, we
yes,
do.
We do.
We do.
So I wonder why we are excluding the website from as a resource, because really I can see everybody calling for anything, which I'm sure already happened.
Mm-hmm.
It feels like an invitation. Just give us a call and check on everybody else you know. I mean, we want transparency. We want a process that allows people, obviously. But I'm thinking about, is this really sustainable, for lack of better terms? In terms of,
It will definitely increase the call volume.
Right.
So, which we will say, you can do that on the website. So perhaps maybe there's
I
some
will add the
value in
website on
adding,
that, yeah.
directing it to the website, and then license lookup.
right.
Or like the BBS.
Give the alternative, A and B. You can either call
I will
or
add
use
that because
the.
that's 24 hours. People
Yeah.
can check at any time
Yeah.
instead of getting that 9 to 5 volume
it.
of calls for that.
Mhm.
So I
Right.
just suggest that, yeah.
Does BBS have a general email box? Then people can actually send email?
Yeah, we do, but I think
Yeah.
I think the phone number, even taking the phone number off might be a good idea because that might change. Who knows? Then you have to do and then just putting it on the website, because the website you
go.
will get more information, just license lookup. We could, I mean, eventually create more information for the public to
Right.
be able to review. So we might consider even taking the phone number off.
There you go.
Okay.
So it's a recommendation, the board members like to remove the phone number and add what? The website information to direct the public to like the breeze?
Or do we want to just leave it as contact the Board of Behavioral Sciences for assistance?
What, but how you contact them? I mean, some
Okay,
people don't know.
So you have to give them something?
Yeah.
Okay.
I don't think there's any harm in listing both the website and the phone number.
Yeah, I
Okay.
think that's clear.
Yeah, because some folks may not, it's hard to imagine, but some folks may not have access to the internet
Right.
or even understand how to navigate it. So the phone number gives them Plan B.
Well, and then the older generation prefer to call.
Yeah.
So I think that's a respectful thing. And yeah. Okay. So the proposal right now is to add the phone number, no, remain have the phone number and add the website. Okay. And public comments? Like that.
Mm-hmm.
Great. I see 2 thumbs up, so I think we're good. Thank you very much. So let's move on to number 5.
Okay. Number 5 is amendments to Business and Professions Code Section 4990.30, petitions for reinstatement or modification of penalty. And the board's legal counsel, thank you, Sabina, has recommended clarifying certain provisions regarding the procedure to petition to terminate probation early or modify a penalty in order to clear up some ambiguities in the section. If you look at subdivision B of the section, it can be found on page 16 of your packet. It currently specifies a time frame after which a petition can be filed with the board. Until recently, the board has operated under the assumption that the time during which a probation is told also counts toward that specified time frame. However, there was a recent case in which an administrative law judge challenged that assumption and stated that it was incorrect. And so staff wishes to clarify that the time frame exclude any periods of probation tolling. So those would, anytime it was told, would not be included in that 2 or 3 year time frame or whatever is specified as. So that's the first change. The second change is that subdivision C of that same section states that a petition may either be heard by the board or the board can assign it to an administrative law judge. However, the following subdivision, subdivision D, goes on to imply that a petitioner has some say in who hears the case. Specifically, it states, the petitioner may request that the board schedule the hearing on the petition for a board meeting at a specific city where the board regularly meets. Now, the intent of that is obviously if they live in Southern California and the board's meeting in Southern California, obviously they would want to be heard there. But it kind of implies a little bit too that the petitioner has some ability to request that the board versus an administrative law judge can hear the case. And so what we'd like to do is amend that subdivision to clarify the petitioner can only request a hearing location if it's the board that's hearing the case. So those are the 2 proposed changes for that subdivision.
I really like that clarification, for the tolling, and not counting into the time that they're eligible for petition for reconsideration. I think that was happening, that happened in our board meetings.
Mm-hmm.
And so I really appreciate, that the change and be able to,
Right.
clarify.
Prior, I think that's in subdivision A of that section, or maybe it's just the first part of the section. It does say for the decision to be enacted in its entirety, right? And we had talked about whether that meant, what does it mean to have your probation enacted in its entirety?
Right.
And that was kind of part of the ambiguity too, was that, are you just on probation, or is it enacted in its entirety when you're actually on active probation, or you're just in tolling status? And so
Right.
that kind of added to some of the ambiguity,
confusion.
right? And so, because it didn't state what it meant. And I know that it was a concern at multiple board meetings.
Right. So this becomes crystal clear. The entirety means that, it's excluding that tolling period. Wonderful. And then the second part of it, that's really good too. It's just like another it's just really confusing when I read that.
Yeah, because
you're
as
right.
you go through it, it says it can be heard before the board, or it can be heard in front of an ALJ. But then the next section says, well, then or a petitioner can request it to be held at a board meeting, where the location. And so the way we were talking about it was like, well, it looks like you get to choose, and then what if the board assigned it to an ALJ?
Right.
So
Right.
it's a good opportunity.
Right. Very good. So board members, any comments? Nope.
I see that good.
So public, any comments about this particular section? Good. Very good. We're moving along. Number 6.
All right, number 6 is that's a proposed amendment to section 4996.22, which is acceptable LCSW continuing education providers. And currently the law states that social workers can only obtain continuing education from an accredited school if it's accredited by the Commission on Accreditation of the Council of Social Work Education. It does not permit social workers to gain CE from a school accredited by the U.S. Department of Education or by the Bureau for Private Post-Secondary Education. Staff believes this is unintentional. This is not how how we require them to complete CE. But if you read the letter of the law, it does imply that it's got to be accredited by the CSWE. So what we are recommending is amending the section to permit clinical social workers to obtain CE from a school accredited by USDE or the BPPE, just as LMFTs and LPCCs can.
And this is also consistent with the new, I mean, not newish, the continuing education, the approval agency and whatnot.
Yes,
Okay.
and that was the intent. It's
Yes.
just, it needs to be clarified and cleaned up.
Okay. Board member questions?
No, that's good.
Comments?
Yeah.
Good. Public? Clear? Social workers? Okay. At that level of the clarity also? Good, very good. Number 7.
All right. Number 7 is just a duplicative definition of supervision that we found. Currently, there's 2 LPCC statutes that define supervision. 4999.12, which is the general definition section of the LPCC Licensing Act, and then 4999.46.1. We believe that the definition should stay in 4999.12 because that's the general definitions, and it does not need to be duplicated in 4999.46.1. So we are asking that it be deleted in that section.
So this is about deletion. Question, so that you don't have to redefine and redefine. Okay, public comments? Okay, awesome. Moving on, number 8.
Okay, number 8. This is something that one of our enforcement managers brought up to me, and it's kind of a mystery. We're not really sure the history of why this is here. Other boards have this too. So there's sections in the Business and Professions Code that talk about fines for Licensing Act violations. LMFT and LPCC law both have provisions establishing a misdemeanor charge and a fine of $2,500 and/or 6 months in county jail for violating the respective licensing acts. The reason it's an LPCC law the same is because LPCC law was modeled after LMFT law. Well, LCSW law has the clause as well, but the fine amount is only $1,000. LEP law states that the violation is a misdemeanor, but it does not specify any fine or jail time. Staff believes that it doesn't make a lot of sense to have the stated punishments inconsistent. It doesn't necessarily, I mean, what the amount is up for debate or discussion, but it should be consistent across the license types. Trying to do a little bit of research, both of the sections were established in, one was LMFT, I believe was 86, and LCSW was 85, or vice versa. They were both in the mid 80s. So we can't really go back. We don't have the luxury of having all of the reasoning and explanations for everything we did in the 80s on the computer. So we can't really go back that far and figure out why it was done that way. The Board of Psychology also has a similar provision, and their fine is $2,000, and it was established in the mid 80s. So we don't really know. We've contacted well, I'll get to that in a minute. The fines appear to be court fines. They're not fines that BBS does. We can't give anybody a misdemeanor or throw them in jail. But we have our own fines that are established pursuant to Business and Professions Code 125.9, gives us the authority to establish penalties, administrative fines, and regs. Our fines are $2,500 up to $5,000. But we're not really sure where this other one comes from. So we reached out to the legislature, the Assembly Business and Professions Committee. They've flagged it as a good cleanup candidate for our sunset bill, if not the omnibus bill. I've reached out to our DAG to try to find out, and they're looking into it. We'll see if we're able to get an answer there. We haven't really been able to get an answer as to where that came from, but we'd just like to make it consistent. So we'd like to propose to just make it a $2,500 fine throughout the 4 license types. Have the consistent language that's in LMFT law throughout the 4.
So, yeah, Max, go ahead.
No, I'm all about the consistency. It just, I just don't feel comfortable to just pick a number because I just don't feel comfortable about that. So I don't know. I wonder because for our fees, there is a process. I mean, we know that there's a recovery cost, how much it costs to do certain action. So we're trying to recover, but here really don't have even the understanding of that. So I just would like, I'm all about the consistency. I think it's ridiculous that there are different fines, but where are we coming from with the number? So can we maybe find out a little bit more about that?
I'm hoping through if this goes in our sunset bill, that we'll get a little bit more background at that time and where it comes from. Kim?
Yeah, so this is probably more a question for Sabina, since this is really tagging a criminal or a civil action. Right. Could we eliminate the fine amount and just say a fine as determined by the court?
That's a good question, and I don't know the answer to that because, like we were talking earlier about this, it is a criminal.
Right.
These are not administrative fees or fines.
Right.
And so, like, we were trying to figure out where they came from, and it almost implies like a violation of that other practice act is not as bad.
Right,
It's
right,
like,
right.
It's only worth this much money,
Yeah.
so you didn't do such bad things, but we're going to lock you up or not.
Right.
And I don't know if it's ever been used either.
I'm not sure. I'd like to, I know that we had that one case where there was a court filing when the GAP exam was compromised.
Yes.
I want to say that the fine issued in that amount civilly was around 40,000.
And you don't know what else was playing.
And I
into
don't
that,
know what was
you know.
playing into that either. So, you know, I don't know. Yeah, if we could find out because I agree there should be a fine.
Right.
But, you know, in some situations, I can see where 2,500 is probably just a slap on the wrist depending on the violation.
And you have to assume, or I guess you must assume, or that you also will see those people administratively.
Right.
And just not criminally. And
Right.
we obviously don't have that criminal authority.
No.
So, and yet not, also, like the, the cite and fine, like
Right.
the CE thing, so it is a violation. Does it fall under this clause?
No, the cite and fine is
It's
under
different.
another section in law, and it specifies kind of we can fine up to,
Right.
depending on what that is, depending on what the violation. I think unlicensed activity, I'm going to just go off the top. I think it's 5,000 for unlicensed activity. All other violations not to exceed 2,500.
So this is really about the criminal charges.
Right.
That it has to go through court and then, what BBS can impose. We are not
We're not
doing
doing it.
anything.
We're not doing that.
So
We're
what
just-
about we just leave, say, we'll be fine, and then just leave the dollar amount out?
I think that's a good idea. Because my hope when I started researching this is we'd be able to pinpoint that it was some sort of court rule somewhere, and we'd go back and it would say, oh, it's $2,500 for everything, but it's not. We haven't been able to find that. So what my thought is maybe we leave it the amount. We don't say an amount, and
Right.
we put this
Determined by
in
the
this.
court?
We try to see this in the sunset bill, and it'll come out. If there's supposed to be something consistent, if the legislature wants it to be consistent across the boards, then they'll either put in an amount and we can take a position on it, or it'll stay blank without the fine, and we'll just go from there.
Right. You could say as a fine determined by the court until then and see what they think of that, maybe. And then if they don't like that, if they really want a number, we'll have a chance
To negotiate that in.
to take a position on it.
Right.
Because we don't have any.
We have no authority.
I think that's where I'm struggling.
Why?
Why there's a little part of me that's asking me why we're addressing this if we have no authority.
I think it's more a signal to the court in a criminal matter that this is a violation of a Licensing Practice Act. We're
Okay.
just making
Yeah.
that known.
They all have
But, I'm personally hesitant about establishing a fine because that gets negotiated all day long for a variety of different reasons, for a variety of different violations. I mean, it's different to get a license by fraud from, hey, I forgot to do my CEs, or, hung up my shingle and I really shouldn't have been. I mean, it's just, there are too many nuances in the law for us to say straight across the board, here's what the fine is. I guess is what I'm trying to say. And I think that's the court's purview.
And you aren't the criminal court.
No, we don't even participate in that process, ever.
Right.
So I recall that there was one unlicensed practice, using the MFT.
Right.
Yeah. And I think that is exactly going through the criminal court.
Right.
And, even so that we don't decide on.
We do not.
We don't, yeah.
No.
So I think, if we, like Sabina said, that, we add the language, take the amount out and replace it with as determined by the court. And I think that is, that we can, it will be consistent across all licensees and yet also clarify that, it is a court determination, not
And
ours.
through this process, we might be able to get more information,
Right.
reasoning behind it.
That's what I'm hoping.
Right. And we might find out there's a reason behind those amounts
Mhm.
and why they want the amounts.
Or we
I
might find
hope.
that they haven't been updated since the 80s
right.
and they're
Now
not
they may
current.
be
Yeah.
$20,000. Yeah.
Yeah.
Who knows?
Yeah.
So that works for me.
Okay. So public comments, we talked a lot, discussed among ourselves, and Janley, you're the historian. Yeah.
Janley Wong, NASW. Actually, the mid-'80s predated my time.
Oh.
But I do want to give you some practical experience that we've had. Occasionally, we find out that someone's practicing without a license or registration, and someone's calling us, usually a member, and saying this is happening. We, of course, refer it to the Board of Behavioral Sciences, but we also found out in the past that it's really up to the local jurisdiction to pursue any kind of action because the offense is a misdemeanor. And there's a lot of discretion on the part of, for example, the county district attorney to pursue a misdemeanor. So in a few cases, this was years ago, Orange County, of all places, the district attorney was contacted and said they wouldn't pursue this because it was a misdemeanor, it was very low level, and they were busy with felony cases. So I just wanted to point out that that's kind of a situation we have when you have this split kind of thing where you're relying on the local criminal justice system to pursue some of these violations.
That's been my experience in some of those cases as well. They just don't take them. So we do our thing, and there we have it.
Right.
Probably see less and less than that with the backlog in the courts.
Yep.
Yeah. Okay. Good information. Thank you, Janley. So now, in that sense, so looks like the only two amendments that we have is number 4, to add the website, and then number 8, add the language as determined by the court. So, and that would be the whole, that would be.
Right. So you're going to
the motion.
recommend, right, you're going to recommend to the board that they pursue this as a legislative proposal, either, however the staff ends up doing that. I know that Roseanne talked about a couple different options.
Absolutely.
Yes. So we would discuss changes to number 4 and number 8 and recommend that staff make the discussed changes, any non-substantive changes, and bring to the board for consideration as a legislative proposal.
Okay. So that would be, so I will make a motion what Roseanne just said. And I need a second.
I second that.
And Betty second. And any other public comments? Okay, good. So we can call for vote?
Okay, Christina Wong,
Yes.
Betty Conley,
Yes.
Max Disposti.
Yes.
Motion passes.
Thank you very much, and good job, Roseanne. And Sabina, thank you. And let's move on to the next agenda item, and that's the proposed legislation, the amendments in regarding the enforcement process because of the passage of AB 2138 and AB 2396.
Yeah, these proposals are pretty much along the same lines as what we just discussed, but I wanted to separate them because they center around a specific topic area. And my thought for these is we would maybe propose them as part of the Omni Bill. If they were too substantive, we could ask that it be considered as part of the Sunset Bill as well, just in case any of the changes were a little bit too much for that. But there's a few changes that are needed in our law because it is due to the passage of AB 2138 and earlier with AB 2396 a couple of years ago, there are some inconsistencies that we need to clean up. AB 2138 made amendments, of course, to DCA board's enforcement process, including placing new limits on when a board can deny a license based on a conviction or formal disciplinary action. AB 2396 amended the same section as 2138 did. It prohibited boards under DCA from denying a license solely based on an applicant having certain types of expunged convictions. And so there's 4 different areas that need some minor cleanup. The first is the qualifications for license or registration. There are these sections that are listed here in number 1. List criteria needed to qualify for a license or a registration. And one of the criteria is the person must not have committed any acts or crimes, acts being the key word, constituting grounds for denial of licensure under BPC section 480. 480 is the section that outlines the reason the board may deny a license. Section 480 used to state that a denial of licensure was based on convictions or certain acts involving fraud, dishonesty, or deceit. However, that language was changed with 2138, and now denial is permitted based on certain types of convictions based on formal discipline due to professional misconduct that occurred in a specific time frame that is substantially related to the profession. So the word act doesn't really play into it as much anymore. So given the recent changes, staff recommends striking the old language that the applicant must not have committed acts or crimes under 480, and instead recommends an amendment that simply states that the person must not be subject to denial of licensure pursuant to section 480. So we're basically referring to section 480 because that section overrides a notwithstanding section, which means it already overrides every other section. So that would be the cleanest way to make that consistent.
So, board members, would you like to refer back to 480, and then 480 can do whatever they want
its
to,
job.
and then we don't have to worry about that. Yep.
Right.
Good.
We really don't.
Yep. Public comments? Okay, very good. So number 2, Roseanne.
Number 2 is in the same sections. So this gets a little complex here. There's a reference in these sections to Penal Code Section 290. Penal Code Section 290 specifies various types of crimes for which registration as a sex offender is required. So as of January 1, 2021, Penal Code Section 290 is going to be reorganized. And under the new version of that law, the types of sex offenses have been organized into 3 tiers depending on the severity of the crime. The higher the tier, the longer the registration as a sex offender. So there's, I think tier 1 is like 10 years, and then there's 20 years, and then there's forever.
Oh, wow.
So, and I've included in attachment D the old PC 290 and the new PC 290. So that's going to be changing. At the same time, AB 2138 amended Business and Professions Code 480, and that has reference to 290. So it references the new 290 with the tiers. It says that only the 2 higher sex offenses in PC 290 are subject to license denial regardless of the 7-year age limitation. However, there are several sections in the board's practice acts that specify denial for any registration required under 290. However, that is overridden made by the changes in AB 2138 because Section 480 says notwithstanding any other section, which basically means overriding any other section. So it means that our particular sections that are saying just referencing 290 flat out are inaccurate and they're overridden. So they're already overridden. It's not quite correct to say that. So what we are recommending is to amend the sections that are listed above that are referencing 290 to say that the registration, any denials due to PC 290 registration must also be in accordance with the conditions for denial specified in section 480.
When you have so many different type of codes.
Yes.
And then what is overriding what?
Right.
You know? So this actually really helped that, to really layer it out,
Right.
So, ultimately, which section that,
And it's just referring back to 480 again because that's what's changed.
Yes.
Right. It's kind of a signal like you can deny based on 290, but be sure to check 480 too.
Right.
Exactly.
Because
Right.
they're telling you how to use 290.
Yeah.
Right,
and
right.
it's not in effect yet, 290.
Right.
See, this is the complexity of law. You cannot just read one section. You always have to refer back, to different part of it. Yeah. It's a domino effect.
Right.
Yeah. So board members, any comments?
I'm just trying to figure out why we got to this. I mean, what is the challenge that we had so far in terms of classification? So, yeah.
So it's basically, there's a lot of changes going on with Section 290,
Right.
which becomes effective at a date in the near future, and then 480 kind of limited how 290, the denials under 290 could be used. So our law just says 290 violation, deny. But 480, which overrides our licensing act, it's not that simple anymore. There's certain exceptions. You have to look at 7 years and the tier of the offense. And so it just makes, it's already, 2138 already made 480 override our licensing acts. We just want to make sure that our licensing acts read consistently with the new law. We don't want to be contradicted, because somebody could read our licensing act and say, well, it says this. Well, yeah, it does, but this section over here that you're not looking at overrides it already. So it's not technically correct.
So if you refer everybody back to the 480 or the 290, then second to the 290, right? We're referring them back to the governing law instead of trying to, because we shouldn't, just like the Moscone Knox example, we shouldn't be reiterating something in our own law that's being affected by or governed by another code section when they're changing those. It's just referring back to 480, which then talks about what tiers in 290. It's confusing.
Pretty much so, because I'm really lost. I'm just so my concern as a public member is also to make sure that, because there's a lot of stigma around this and the language and everything else, that we're not creating any additional barriers. I'm just going to bring an example. I had a therapist that was a sex worker, and a great therapist too, but that was her past, and what she had to go through in the licensing process was just unbelievable. So I want to make sure that we're not adding more to, we're not.
No, not with 2138 and all the changes. No,
Right,
that's the
that's
whole
exactly, because
point.
I follow that conversation. So I
Yeah.
want to make sure that we're online with that. Okay.
Literally reflecting those changes.
Okay.
Yeah, it's actually the tiers actually for somebody with a lesser violation, a tier 1 violation, it actually gives them a
licensure.
door in.
Yeah.
So the tier 1s have more of a door in under this than they would have under the old law.
Right.
Right.
So it's actually would be helping promote them possibly.
Because before 290, you're done.
You're done, yeah.
No.
Yeah, no, I'm
Yeah.
very
So,
familiar
yeah.
with that. Yeah.
Now we have
refer to
tiers and we can
480.
look at a couple things.
There is a different level of gravity that's been created within, even though it's still, in my opinion, but that's okay.
And I think, I remember, correct me if I'm wrong, the intention for those two passages of the bills are really not to over-criminalize, those licensees who have license, and to remove some of the barriers that, that might cause them to find, jobs and stuff like that. And so, yes, it's more complicated to have different tiers, but really it's helping them, helping the board to take a look, that, to have the appropriate amount of the discipline, and to protect the public. So not like, you're a sex offender, bam, out, now they have the tiers, and so it's really about referencing and, so for the board to be more, responsive.
Right. No, I see that. Yeah. Okay.
Great. Good feedback. Public comments. Thanks for waiting.
Chair back.
Yes, absolutely.
Rebecca Gonzalez, NASW. I just have a question and a quick suggestion. So I'm sure you said this, but I'm just double checking, because the 290, right, doesn't change until 2021. I mean, this scheme is still going to work. Okay, just double checking. And then, since we work, we have a council at NASW, Rehabilitation and Inclusion Council, that works with social work students and some social workers who have a past criminal record and trying to make things smoother for them, and they're always interested in transparency and making things very understandable as much as possible for determining whether they can get their license for the students. So I'm wondering if on your website you could talk about those tiers in 290, and that would be one way for them to look at the website and get a better idea of where a particular offense may fall. And I think that would be really helpful, and people would really appreciate that.
I'm assuming there's going to be a lot of frequently asked questions.
Okay.
The 290, it's coming the new year. And
Right.
like I was just saying, I feel like we need a flow chart.
Okay.
I feel like
Yeah.
we need a, conviction, yes, or, I mean, just some kind of idea to help people with convictions to see how this even works, because it is confusing.
Yes.
Like-
Okay, thank you.
Thank you, Roseanne. Thanks.
And Sabina, since you talked about the different tiers, and I was about to put in the future agenda item that maybe it will be a really good education even for the board members, to understand the different layers.
I'm sure, and
So-
licensing or something could come up with
Right.
a presentation.
So I'll make it official for my request, in that item, so that we can put it in the record. And Betty?
Well, I just had a question, and I think Rebecca asked this and it was answered, but I don't think I understood the answer. So this doesn't come into effect for a year and a half.
Right,
Where are we in the interim? So are we still excluding people who are on that tier 1 in the interim, and we have no recourse on that, right?
I don't know that we've had a lot of applicants like that.
Okay.
First and foremost, and second, AB 2138 provisions go into effect July 20.
Okay.
And then the 290 provisions go into effect 2021. And if this proposal is successful, those will all occur around the same time.
But you're saying we don't have a lot of applicants for whom that would...
Not usually.
But also because they just know that there will be no chance to even try. I mean,
Well,
overall, because in any aspect of the law, in a social, they just have access to nothing. So,
Right. And I think that sometimes the schools might not.
Yeah, and I just want to add sometimes there is so much stigma in this conversation. People might think that it's the heavy cases of sexual child abuse. The majority of cases we're talking to people who have been stigmatized. They were sex workers. My LGBT community has been targeted. There are sting operations from the police, and you become all of a sudden on the sex offender list that your life is completely ruined. So a lot of people don't even think about the possibility to apply for any license because you are absolutely outcasted from any social aspect of it. So I just want to, perhaps a conversation around this in the next is going to be an agenda item, you said, Christine? Is that what you're proposing?
No, just the FAQs and just.
future- okay.
Yeah, just to informational, so we
Okay.
can develop something and present it to
I
the
think that
board.
would be very useful
Right.
for the record too.
Maybe it's a frequently asked question of, I have a conviction,
Mm-hmm.
what do, can I
Right.
apply? And then just guidance about, what.
Correct, yes.
And we can't tell anybody, yes, you can be licensed for sure, of course, but we can explain this a little clearer.
Better. Yeah, thank you.
Refer to this code, and refer to the other code and
I
that
know.
kind of stuff. Yeah.
Try not to do that.
Yeah. All right. Thank you so much. So let's move on to number 3.
Okay, so number 3 proposes amending 4 different code sections. They're the unprofessional conduct provisions for each of our license types. These sections contain a definition of a conviction, and AB 2138 amended the definition of a conviction that's located in Business and Professions Code 7.5 for purposes of denying a license pursuant to Business and Professions Code Section 480, which is the main section that 2138 amended. So staff recommends, instead of specifically defining conviction, they're just referencing the definition in 7.5. These sections also contain language permitting suspension, revocation, or denial of a license when a conviction has been dismissed pursuant to Penal Code Section 1203.4. However, due to the amendments made in both 2396 and 2138, denial of licensure is no longer permitted on the basis of this type of dismissed conviction. So that language is obsolete. And it's overridden, so it's already obsolete. Therefore, instead of including the specific language, we recommend an amendment stating that actions to suspend, revoke, or deny a license must be in compliance with Division 1.5 of the Business and Professions Code. And Division 1.5 is the section that contains Section 480 and its surrounding kind of follow-up sections. It's the statutes governing denial, suspension, revocation of licenses. So we just referenced that. It's got to be in compliance with this. It provides a good cross-reference.
Yep. And now the cross-referencing.
Rather than trying to keep the language the same if those change in the future.
Right.
Yeah.
Any comments from the board members? Nope. Public comments? Okay, all right. Thank you. Number 4.
So it's a lot of cleanup. So the last item is amending section 4999.80. You can find that on page 46. Reference to statutes governing license denials, suspensions, or revocations. And this section is a section of LPCC law. It just happens to reference, none of the other license types have this. It references laws governing license denial, suspensions, or revocations. It does not reference Business and Professions Code Section 490, which is the main section that governs those. So staff believes that 490 should be referenced in there as well. So we recommend adding it to the list of sections listed there.
And now the cross-referencing. So this is, all this about. Any questions? Public comments? Rebecca? Yes.
Rebecca Gonzalez, NASW. Not sure if I should have come up on the previous section, but I just wanted to have a couple of general questions, and I emailed Roseanne about the letter that was sent by Roots and Rebound. Just want to make sure that all their questions are being addressed. I think some of the questions they addressed were really taken care of by the way that you amended the bill, because you would simply refer back to other sections instead of incorporating all the language of the bill into the regulations, and I think I understand that. I guess the two main areas where there are probably disagreement between some of the advocates is not going further in the board trying to define substantially related, and also the conditions of rehabilitation. And so I was wondering if you could talk about that, and also think about ways to make, the website or any information as clear as possible. So I think I understand where the board is coming from on this substantially related, but I was wondering if you had thought about further defining things in any way.
We have not, the board members are not privy to that letter just yet.
Oh, okay. Okay,
Yeah,
sorry.
And it's,
This is not,
Oh.
that's not being discussed today.
Yeah.
Oh, okay. I thought it arrived in time.
no, that's for the regulation.
For the
Oh, I see.
Yeah, this is legislation. Yeah.
This
Okay.
is just cleaning up references back to the
Okay.
codes that were changed in 2138, so that there isn't confusion, so that we clean up our law.
Okay.
So it refers back to everything that 2138 changed.
Okay.
So-
Okay.
So that it stays cleaner,
right.
and there's, we don't have to keep up with the changes in those other code sections.
Okay. Okay.
Comments were specifically related to the regulation
Yeah.
hearing.
Okay. Great.
Yeah.
Okay. Thank you.
So yeah, this is statute, and so what we're doing right now is we're going through the letter, and so I'm reviewing that, and then I'll be giving it to legal, and then it'll go to the board in November. So the regulations will be discussed at the November board meeting.
Okay. Thank you. But I also want to thank you for the work you did, and I think the way that you amended the statute makes sense and makes it cleaner and easier.
Thank you.
Sure.
Thanks, Rebecca. Any other public comments? Good. So we are ready for a motion. So looks like there is no amendments.
No.
It is just like this. So let's see. I think the motion would be what? To direct staff to make any discussed changes, which is none, and then any non-substantive changes, which is none, and bring to the board for the consideration as a legislative proposal. So that would be the motion. I'll make that, since I said that. I need a second.
Hot second.
Thanks, Max.
Thank you. That was
Being
really clear.
courteous. So we have a motion
Yes.
on the floor. I know, right? Your turn. Any other public comments? No, good. So we're ready for vote.
All righty, Betty Connolly,
Yes.
Max Disposal.
Yes.
Christina Wong.
Yes.
Motion passes.
Thank you so much. So it's 9:31. Anybody need to have a quick break or you good? Move on? Okay. All right. So number 3, and I believe it is about the incapacitated supervisors and the record retainment, right? Yeah,
Incapacitated or death or incapacitation of a licensee in their
at the
client
custody, right?
Yes. So
Same.
from time to time, we receive inquiries about what should happen to client records if the therapist dies or becomes incapacitated. Who gets the records? Where do they go? What do the clients do? Currently, our statutes and regulations do not address this. Some professional associations address this in their code of ethics. For example, the American Psychological Association, or APA, they have some language in their code of ethics stating that psychologists make plans in advance to protect the confidentiality of their records. There's some information guidance from APA shown in attachment E of the packet. The American Counseling Association, the ACA, addresses the issue in their code of ethics by saying that the counselors take reasonable precautions to prevent client confidentiality in the event of their death or incapacitation, and they appoint a records custodian when appropriate. And several other states have also taken steps to require that their licensed mental health professionals take certain actions in the event of their untimely passing. For example, and the examples are kind of all over the place. There's a lot of different things that different states do. Texas just requires, as part of the client's informed consent, that they have an established plan for the custody and control of their mental health records in the event of the licensee's death or incapacitation. Florida has a regulation that basically requires the executor or administrator to publish a notice once a week for 4 weeks in the highest circulated local newspaper that states the records will be disposed of or destroyed. Maybe a little old-fashioned now. The state of Oregon, the licensees must file the name of a custodian of record with the board, along with their contact information, and it must be specified people. It must be another Oregon licensed mental health professional or a medical professional, a medical record company, or attorney, among other things. And then finally, the state of Washington just simply states, it's a little bit more vague. It says that they have to make provisions for transferring records. It can be made in a will, an office policy, or by ensuring another licensed counselor is available. So those are just some ideas to keep in mind for the forthcoming discussion. One logical question to ask is how establishing a plan to transfer client records interacts with Hippa. There is an FAQ that addresses this a little bit on the Health and Human Services website about HIPAA. It states that healthcare providers are allowed to use health information for treatment purposes without the patient's authorization, including to consult with other providers or refer the patient. So I've included that FAQ off of their official website, as well as the law they reference in it for your review in case there's concerns there. Otherwise, we just thought it might be helpful to have a discussion about this.
Wow.
So, right, and I actually, really like the idea that, we have some language, to provide guidance, for the therapist, how to handle the, having the custody, of the records. And so I'm good for that, and when I look at, the other states, and, I was just thinking, is like how much, micromanaging then you want, that, our state to be. And so I think in general, it really is a good idea. And I'm more for, I like the Texas and the Washington, kind of that language, that you have a plan, and yet, not specifically telling them what to do. but I think I want to bring it up. You know, the very important thing is like nowadays, a lot of the records are not on paper anymore, and so when they're on the electronic format, then how can we, you know, make sure that those records, you know, maybe, you know, it's really about like accessing the computer, accessing, you know, that whatever the software they use, and be able to disclose or transfer them. And so I think it's more about, you know, the technicality part of it, and, you know, and the formats of those records are no longer just paper, you know, which makes it a little bit more difficult. So that's just my comments. And Max?
I was asking a question. I don't see any distinguish, or maybe I missed it, between someone who provide services within an environment, like, you know, a nonprofit or for-profit, which the agency owns those records. So at that point, even if the person becomes incapacitated or dies, then the agency takes over for whatever period, you know, years. I have requests for people applying for disability and going back for 3-4 years, where the agency wanted to have access to the mental health files, right? Or perhaps a therapist that wasn't even there anymore, but the agency owns those paperwork. So I don't see any distinguish here, because obviously I can see the challenge if someone has their own private practice and now really no one else is there to take care of those, you know, and perhaps the people that around them, they don't even know the Hippa violation, how to deal with the paperwork. They might just trash it too, right? So we definitely need a language, but also I would like to have a distinguish, because if you work for an agency, it appears to be easier, perhaps, maybe I'm wrong, but just that the agency takes over those paperwork. And then if the agency fails for whatever reason, that's another issue. But now you have a legal component where if a therapist works for another organizations, the organization should have primary, you know, ownership, for lack of a better word, of the paperwork. So because they are in compliance with all the other requirements. So I don't see anything. Am I missing something? Because in any state, there is not distinguish between.
Not of the ones we surveyed. They either, with the exception of Florida, they keep it pretty vague.
Yeah, Florida really goes all the way.
Yeah.
I can see after 2 years, someone dies, publishing that every 4 hours. It just, I want to, what happens if you don't? But anyway,
Oh, yeah.
that would be crazy.
Yeah.
Yeah, Betty, go ahead.
So when I first read this, my first thought was, whenever we do a regulation, my thought always goes to, is it enforceable?
Right.
And if is there any accountability that we can require? And with an agency,
It's easier.
that's different. I really feel like that's built into their infrastructure and
Right.
how they've developed their service model. But with a private provider, I think we're in that realm that we were with the practice of unlicensed therapists, and we can make recommendations about ideal best practice and what, I mean, I think it comes into that area of pretty much what we'd be doing would be recommending to people, you know, as an ethical practice that, which goes back to maybe it's not even under the purview of the board and should be the purview of the professional organizations that are developing code of ethics. I mean, I don't know. I'm hesitant to develop regulation that we can't enforce, because if someone dies, they're no longer under our jurisdiction. And the next person that takes, I mean, we have no authority over somebody who's not on, I mean, the what do you call it? The executor of the will,
Right.
who's responsible for all of this stuff, unless they happen to be a license holder, are not going to be under our jurisdiction. So I have some.
Yeah.
And that's why I liked some of the part of the Texas model, because you could modify that to, in the informed consent, that says something to the effect that, you know, if and when I leave this lovely place, your records will reside here with the agency. And then if you're a private practitioner, that, you know, you may access your records here, you know, or contact this person. And so you sort of have an A and a B scenario. Because it's really more about getting the records to that patient. And I've had a couple of different phone calls where the therapist or the licensee has died, and the colleagues don't know what to do with the records. They have no idea what to do with them. What do we do? How do we notify it? So, the informed consent at least provides some information that the client should have a copy of, and then they can pursue the records that way.
So would that make it enforceable if we're saying that you need to designate another license holder and it needs to be specified in the consent?
It's, yeah.
Yeah.
I mean, that's my issue, is let's make it so that
Right, it's
if we're going to say that this is a rule, how do we know that they're going to actually apply?
I think that if it's in the informed consent, that's in the paperwork that the client signs off when they
Yeah.
start therapy. If it's in there, that's more enforceable. It has to be in there. They are required to have it in there, and means they have to think about it in advance.
Right.
So that's probably the best that we can do in terms of
Right.
enforceability. Now, the odds of somebody filing a complaint, they didn't,
Yeah.
are low, but at least it's
Technically
Yeah.
enforceable. I mean, that's my issue, is it technically, is it
If
enforceable?
it's required to be part of their
Yeah.
paperwork
Informed
issued
consent.
Yeah,
to their
and if
patient,
they are required to designate another license holder as the holder of the records,
right.
then we would technically have an enforceable thing
Right.
right
If you
there.
take it a few more steps, what about that designated licensee? They also die. They have falling out with, I don't know, you can take it to 10 million other steps. What if they, no longer are licensed? What if they are incapacitated themselves? What if they don't like that licensing anymore and they're no longer friends?
Right.
What do you?
I think it's more the idea that there is a plan. What happens if? Because it benefits both sides. It benefits, the licensee and errors. It benefits the client if they need those records. So it's more the idea of, here's what will happen if.
Here's who to contact.
Right. And at least if we get the calls, like, what do I do? We can say, well, when you had your initial session, there's in the informed consent, this information should have been provided to you.
So, so the health record really belongs to the clients.
Mm-hmm.
It's theirs. So, so having a way for them to acquire them is important. So how does it look like? We don't know. And I understand what Betty, say is about the enforceable. So even though we put it in, in our practice act, whether that becomes just a suggestion, an ethical reminder, or whether it's something that if you don't do it, then we will put you in jail, or, be.
After you die.
Exactly. So
After you die. I want to see that.
$2,500.
Yeah.
So,
It's kind of working through my head. It's like,
so I mean, but that's really, I hear where Betty is coming from. So, I mean, am I capturing it? Yeah, concern, right?
because if it's a suggestion,
Yep.
But should have a plan. I don't think it's beyond the board's authority to recommend what needs to be included in an informed consent. Right
and
now,
I think that's where we start getting some accountability.
exactly. I mean, because we're already going to, with the notification to clients, the bill that just passed, the vision was really, I don't want it to be onerous on the licensees. So they're obligated to provide an informed consent anyway. So what better place to provide the notification to client, but in the informed consent? So this could just be another component.
I think that's this is a really good area, for the association, to really address it in, in the code of ethics, and also, provide them some guidance, what would be the ethical, ethical practice, to handle this kind of, situation, because, you have all these laws, in about the owners of the privilege and the, the custodian of record and that kind of stuff. And I think, eventually, with, they can reference to what, the board's guidance, but truly, also the better places also to, in the code of ethics in different, in different licensees. And so I think that would be another place, that might be enforceable per se.
Well, it'd be a partnership.
Yeah, exactly. And Steve, you've been waiting. I saw. your hand.
No, I agree with Betty. But then you started talking about the informed consent. I thought that is good, but actually, this is going to be really ignorant of me. Do we really require a informed consent in our statutes and regulations right now? We do say, like, for like registrants, they have to let the client know, but we don't. So we'll have to. I mean, I like that idea though. If we have it in a, we start laying out what's good to have in the informed consent, but putting stuff in there that we cannot really regulate, and maybe even just putting, if we put this in, and I'm worried too, is people then are going to come back, okay, what else do we need the informed consent? So I think it's a big project when we start doing that. If we don't do anything, I would definitely really encourage us to, do some deep research into best practices for that. Because yes, I get this question on at least twice a month, and just had one where, they don't even know how to get in touch with the executor of the therapist, and so they have no idea how to get their records. So it's I always try to refer to Hippa or what the actual rules are regarding client records, but I think I like the informed consent idea. Also, though, just education might be another route. So.
Steve, thank you for framing this, because I think we need to really look at it. It's like, if let's say we adapt what Texas law is to put in an informed consent, then the informed consent will become a requirement, a lawful piece. And so I want to make sure that when we proceed, then that we're not complicating our requirement for the licensees in terms of the practice. So, it definitely is a good place to put it in the informed consent. And I can, almost think that, that it is a very practical issue. For example, like, a therapist, seeing a client, and client wants the recommendation or the health record, to apply for Social Security. And if the client, if the therapist passed away, then, then that becomes an obstacle. I mean, so these things are very real. I'm not even making this up. So I think that's, whether it's coming from my suggestion, coming from the association, or coming, the embedding, that suggestion in our law, I think we definitely worth, some investigation. So,
So are you suggesting then we just kind of research a little bit further?
Yeah.
And then see what that might look like?
Absolutely.
If
Because-
we include it in an informed consent?
Right.
Okay.
So I think, first and foremost, do we like the informed consent idea? And yet, I mean, would that be a direction to go? Or
I like it. To me, and then I'm really curious to know what the public has to say, to be honest, so that perhaps it could really be helpful for our.
Absolutely.
But it just I want to make sure that while I agree with what's been said on the reinforcement aspect of it, but at the same time, I do believe we're issuing licenses, and so there is a creation of documentation, so we can just. Not that you say that, but in general, not take responsibility for it. That's right. So we need to make something that could be reinforceable, because those documents are, they're being produced during the jurisdictions of licensees. And I think we have the responsibility towards the public to make sure that we assure, the accessibility of those documentation, so that we can actually, and the way we do it, I'm open to it, but I think it's just something that we need to make sure that we think about it.
Yeah.
So,
Steve?
really quick on the enforceable thing, I think there's other agents like Hippa and stuff. I'm assuming there's other federal agencies that do have the regulation, which have more power than us on with that. I don't know if we got into the practice that we do put it in here as a regulation. I'm not sure we're going to want to do audits of consent forms. So, I mean, that's kind of just something.
No, but if we do have that, and if we sort of establish what a good informed consent, the components of what it includes, then that is something that we could promote out there to the public, that said part of good practice is at the beginning you receive informed consent. It should include at minimum A, B, and C.
Well, yeah, no, I totally agree
Yeah,
with that. But
yeah.
in statute and reg, or could we just put that as this is best practices by the board, or in something, could follow for consent informed, please, for best practices, follow the, I mean, I don't know. I think it definitely does need to put out. I know.
I would like to, like Max say, let's open to the public.
Yeah, let's do it.
And, have you all and come and give us some of your, suggestions.
Jacqueline, California Society for Clinical Social Work. As a clinician, I really appreciate this conversation. As you all mentioned, it's needed. And the other side of it is discussing the different options, like for informed consent, for example. There is not a lot of clarity around what that appropriate template would look like as it's changing and we're adding and removing things with it. So defining that and coming up and giving advisement, I think is definitely needed. Should this be incorporated in that as an example versus something that you're going to be enforcing? Definitely, it seems like it could go either way. There's pros and cons to either side. But the part that I wanted to bring up is that as a requirement, for example, where you're having to submit to the board, like during licensing and things like that, I think would be too cumbersome, and actually there'd be too much change in the profession that you wouldn't be able to keep up with it, or it wouldn't be up to date and things like that. But in the informed consent is something where when you're establishing with a client, it seems like it would be more appropriate to live there. And then on the other side, from the society, should we discuss what the recommendations would be? I think that it wouldn't be best to live there because this is something that impacts all of us as therapists, not specific to LCSW or LPCC. So I think the informed consent model does make a lot of sense. However, with that, I think in general, that's a larger issue that needs a little bit more clarification. Thank you.
Thank you, Jacqueline. Any other comments? Hi.
Hi, Kristen Roscoe from CAMFT. So first, thank you so much. This is an issue that comes up from our members or former members almost weekly. We hear from family members as well as colleagues calling in with, what do we do? And it runs the gamut of, I don't have access to records, to the records are in the widow's garage. So this is certainly an issue that we're very aware of. So we do include in our Code of Ethics, Section 1.3, a reference to having a professional will as a recommended practice. So that's something, obviously, it's just a recommendation, but it goes in conjunction with the idea of having undisrupted care for patients. So that is something that we recommend to our members. We have at least a handful of articles on how to draft your professional will. So that's something that we're certainly in favor of you looking at. We would not really be supportive of anything that would put a burden on the family members, similar to the Florida recommendations. So, but as far as having information contained in the informed consent, to put the public on notice as to what to kind of look for should something happen, because inevitably something may happen. That's certainly something that we're in favor of. So thank you.
Thank you very much. Wonderful. And now we have the LPCC.
Morning.
Good morning.
Morning.
Kenneth Edwards, California Association for LPCCs. I wanted to echo an earlier comment about the records. I'm a private practice clinician as well, and there's not one piece of paper in my office that I would literally hand off to someone. So in the language, as we're discussing, should we, include just the word and electronic records as a piece so that we wouldn't have to develop a whole other set of language? And by that same token, I mean, how do you provide access to that for someone else? I mean, do we have a little envelope with your password in it? I mean, which, in the event of my death, please pass this along. And, you have to change your password so often. So I like the idea of not sort of codifying it into a regulation, but recommending a plan of some sort. so that people will have that. We were also just discussing right now, this is one of my board members, by the way, you all will get to meet later, the idea that the association should develop a template. I mean, just one of our peers back here as well, to sort of recommend how to make a plan of passing these things along.
Okay.
Yep, thank you.
I like action and collaboration. So that's wonderful. So thank you. Thank you, Kenneth. And Jan Lee.
Janley Wong, NASW. You've opened actually quite a complicated subject, even though it sounds simple. But in terms of agency practice, there are pretty strict rules in agencies regarding record retention, as well as transfer to other clinicians when a clinician leaves, dies, goes on vacation or something like that. So I don't think we need to worry about agency practice that much, as well as you do have some general rules regarding record retention. So you shouldn't have to worry about that too much. Private practice is another situation that's pretty complicated. So I think it'd be helpful to think of it as some people don't die during their private practice. They decide to retire, they close their practice, and mostly they know what to do. Usually, if they have active cases, they transfer those cases. If they have really old cases, it depends on how old the cases are and what they think the need is to keep those records. For example, some practitioners are in practice for 30 years. They may have kept all their records for those 30 years. So some of those records, some of the clients have died already. So I don't know why they kept the records other than they had the garage with all the boxes in it. So anyway, I agree that I think Betty brought it up regarding jurisdiction. I'm not sure you have jurisdiction over the dead as well as their effects. Their estate is basically what we're talking about. Also, you have to be careful with this because if you start getting into that area, you might be talking about probate and trust law. And I don't think you want to go there either. So people say, well, you should have a professional will. That's a good recommendation, absolutely. But you don't want to put that in statute because then you're getting into that other area. And for the most part, those practitioners that die and don't leave anything, instructions or anything, some of the clients actually, you've already mentioned this, contact the estate administrator or the executor of the estate. And it's kind of a gamble because the estate administrator may not know what to do with the records, may destroy them, may not destroy them. I like Edward's comments about electronics and password. It's pretty complicated. I don't think we should put people in a position of coming up with passwords and giving them to other people, or if the person dies, the estate contracting with a hacker to break into the records. I think that's like way, way beyond. The consent form is a little complicated. A lot of people think we could just add everything in the world in the consent form. It's just, everything we want to tell the client, we'll just make a 10-page consent form. And of course, when you ask the clients to sign it, many of them don't actually read it, especially if it's 10 pages. They just say, where's the sign? I'll sign here. Consent form is really intended to not necessarily get consent because the person showing up at your office and agreeing to undergo therapy, there's a verbal agreement there. I know attorneys probably like the idea of, well, it's formally, it wasn't done against your will or anything like that. So it's more of a legal documentation, but it's also very important to explain the limits to confidentiality. That is really a very important part, and usually it's done within the consent form because the consent form says you consent to treatment and I, the therapist, agree to keep your stuff confidential except for these exceptions. So adding on all this other stuff is tricky. For example, well, here's who you go to if I die. You know, first of all, if I'm a client, I don't know who that person is. And secondly, I'd start feeling like, is my stuff not confidential? I mean, you're telling me that there's somebody else that might have access to my stuff, and they may have access to it before I die. You know, if you're negotiating with another therapist and saying, well, if I die, here's the key to my file cabinet, here's my password, who says they can't go there before I die? Now, somebody might say, well, they're honorable, they're ethical, they won't do that. But does the client really know that? I mean, what does the client think? And if you disrupt the idea of confidentiality and trust and relationship building, then maybe that client won't want to see you or may have doubts about you. Like, what else are you going to tell people about? I think this is another area that's kind of complicated. Is somebody mentioned the client owns the records. Well, technically, the client has access to the content in the records. If they're paper copies or electronic copies, usually the originals are, they belong to the therapist. You know, if a client comes and says, I want copies of my records, usually you don't give them the originals, you give them a copy. Somebody may be giving them the originals, that would be bad. The other thing is there's some content that belongs to the therapist in terms of interpretation or professional, clinical insight, perspectives, treatment planning. Even the diagnosis actually belongs to the therapist, not to the client. So when you say this belongs to the client, yeah, what the client says in a session, if it's written down in the record, sure, that's what the client said. But if the therapist is writing stuff in there, that belongs to the therapist. The therapist is the one writing the stuff in the record. So again, I think it's pretty complicated. You know, we generally don't like anything Texas does. So,
Yeah. Florida.
yeah, fair
This
enough.
time it's like, there's always the first.
So I like the idea of let's take some time, think about it. Let's ask the professional associations to weigh in. You know, I think our association should take a look at what we put out. We do put out a template consent form. The others do too. You know, we should take a look at that. We should raise this issue with our people, our professional experts in this area. I understand we want to help clients out, and believe me, all of us get the same calls you all get about my therapist died, what do I do? I understand that. And it's an important and good question. But in the end, if somebody needs to continue therapy, they're going to start with a new therapist. And in the end, yeah, it'd be great if the therapist had access to the records of the former therapist. Many times they don't. They just kind of start all over again, and they do their own assessment and evaluation. You know, a new therapist worth any kind of professional standard is not going to simply rely on what's happened with the former therapist. It's helpful, informative. They may come up with a different diagnosis and treatment plan. They should be allowed, these new therapists, to have that leeway, share that with the client, and the client has the right to say, I don't like that. I like my old therapist. I like my old diagnosis. I like my old treatment plan. It's this kind of give and take between a therapist and a client. So we should respect that too. Thank you.
Nice. Thank you very much, Janley. You know, there are all these areas that definitely, you know, we need to take into consideration. Hey, welcome.
Hello, my name is Beta Rivas, and I am a member of California Association at LPCC. I am new to California, so I just wanted to comment that I appreciate the conversation around informed consent, because coming from Colorado, there was a template that the board gave where there was mandated information that must be in the informed consent. And as a counselor educator, I find that not having a little bit of a template is very confusing. So I'm glad that there are these conversations around what should informed consent look like, and what information should they have access to. In respect to the idea of how do you disclose what the plan is should anything happen to you around client records, I feel like that is really well assumed under Hippa, because we have to, as a clinician in private practice, or I was in Colorado, I'm new here, we had to give, Hippa, the HIPAA notification. And within that, you had to have a policy and procedure within your practice that you disclose to clients. So those are things that we can highlight in practice so that it's given under HIPAA versus complicating it, just like other people have said in the informed consent. So I appreciate the conversations around informed consent because I feel like that's really important. But I do think HIPAA includes policies and practices around maintaining client records. So thank you.
Thank you very much. So this is more complicated than, just, how do we manage those records? You have the HIPAA, you have, whether, even informed consent is a legal or ethical practice, how much enforceable, so these are, I think these are gray areas. So I would really suggest that maybe we do more exploration, and to really take into that consideration of the feedback from, from the associations and just take a little deeper look at that. Yeah.
I think that's probably a very good idea.
Yeah.
I'm really interested to see what Colorado has as well as the HIPAA information that she mentioned.
Right. Yeah. And then,
And if it's covered there, then okay.
Right.
But at the moment, there's nothing in California.
nothing.
So
There's
that's-
nothing in
that
Cal-
It is.
yeah.
It is.
It is concerning when there is, no guidance, and I'm glad that CAMFT actually have the, have your code of ethics is already included. And so, so I think my question is like, do you want to make it a legal practice or whether it's an ethical practice? Because the ethical thing is like, this is the guidance, this is what you should do, and the legal said you must do. And so I think, that really is about like, how far do we want to go from that point? So, so that's why I said if it's illegal, if it's illegal, then definitely, how do we, incorporate in our statute and, and how enforceable it is. And if it's ethical practice, then how can we go by, whether it's just a suggestion or whether it's like, through the code of ethics with the other association. Does it pretty sum up, Okay.
We'll bring it back.
We'll bring it back. Awesome. So no action needed. Wonderful. So let's move on to the next.
But sorry,
okay.
is there a mandate to staff to research in other states, in other legislative? Okay,
Well,
that's the
well,
man.
yeah.
So there is an action.
Yeah, staff is going to research.
Okay,
Staff is going to research.
I just I didn't
Broad
mean
enough
to,
for us
yeah.
to peel back some layers of the onion.
Okay.
And we like Texas this time, so this is good. All right. So the last, actually, the next, agenda item is is Christy, to talk about the proposed regulatory changes to examination waiting period, professional cooperation, accredited agencies, and relevant degree.
Thank you. So this is a reg proposal on some different topics, none of which are very substantive. They're fairly technical, but they do require a regulation through the normal regulation process. So, and looking at probably running these in one package, we'll determine that as we go along. But the first one has to do with examination waiting periods. Right now, the LEP exam is not specifically identified as to the waiting period, so we would go with 180 days, which is our current practice. We would reduce the waiting period for board-developed clinical exam, which right now is just the MFT exam, to 120 days, which is our current practice. And we would specify that examination waiting periods are a minimum. Right now, it just says it's this many days. And this would give us a little flexibility in case there was some sort of event outside of the board's control. We wouldn't anticipate extending those waiting periods for just any reason. It would be something, pretty major. The next topic is the professional corporations. We just have LPCCs that are missing in a section that we need to have for consistency with the LMFT and LCSW professions. It has to do with ownership and transfer of shares and how you name a professional corporation. And the last one has to do with accrediting agencies and equivalent degrees. There's a section that's talks about equivalent accrediting agencies for MFT applicants, but it's no longer necessary as it's fully covered in statute. And then we need to specify accrediting agencies acceptable for the LEP programs for consistency with the other professions and update the name of the foreign credentials evaluation services. So that's it. Pretty standard.
Yeah, I just have a quick question about the examination waiting period.
Sure.
So when we change it to 100, reduce the waiting period for the clinical exam to 120 days. So I wonder, so is that consistent with, what about the other license type?
The other license types are a national exam, and so we don't have control over those waiting periods.
Right.
It's up to the national
So they
vendor.
will be, okay.
Yeah, so we say a board-developed clinical exam
Right.
at
right.
120.
What I'm really thinking is about, that I know that they take the national exam. So, and it's really about how many times that the clinical exam can be taken among the licensees. Because if we reduce it to the waiting period for 120.
That's what we're doing now.
Oh, okay, so
That's
the
what we're doing
practice.
now.
Okay.
And now, if I recall correctly, the reason that we're doing 120 is because that is what's happening at the national
At the
level.
national level.
Because that's, at the national level, they get at least 3 opportunities to take the exam
So
per
it's
year.
Okay.
So we wanted to make that same
That actually is
provision.
consistent.
But what Christy's pointing out is that we have 180
Yes.
in the law, and we're doing 120.
So the practice really is 120, but the law says different. Okay.
Right, because we have 3 different versions being released of the LMFT clinical,
Right. And so,
A year.
so they can take 3 times per year
if they're on it, yeah.
if they're on it. Okay. Betty?
I have 2 questions, both related to LEP licensing. Shocking. So the first question has to do with 180 days for the retake on the exam. And it says, the way you wrote it, it says, this is not specified, the retake is not specified, but 180 days is consistent with current practice. My question was, is it consistent with the other licenses in terms of their retake? And Kim is shaking her head no.
No, because we do a board-developed exam, and for the LEPs, mainly because of the volume, we make 2 versions of that exam per year.
Okay.
So that's why it's the 180. With the LMFT clinical, again, higher volume, more people coming through the testing cycle, we're saying 120 to be consistent with the other national license examinations. And if I believe LEPs, I think we're the only state that licenses them. So,
Okay, so the rationale for the 180 days has more to do with the fact that there are only 2 versions of the exam.
correct.
And so while other licenses may be able to retake the exam more frequently, the exam is substantially different, so it doesn't compromise the retake validity. Is that?
Well, and that's the whole point of the different versions in the
Okay.
waiting period, because once you're exposed to an exam,
Right.
you should not retake that
That
version
exam for probably a year.
for a period of time, because there's recall, you've been exposed
Right.
to it.
But
Doesn't-
at this point, we're saying it's a year for LEPs because it's,
twice a year, they can do it twice a year.
but
180.
they can take the other exam.
Right.
So it's a year from the
No.
initial exposure?
No, it would be 6 months.
Okay.
Yeah, and that's what it is right now, and that's what it was for all of our board-developed
Right.
exams. We were only developing 2 versions for everybody. We bumped up LMFTs primarily to align them with clinical counselor national exam and social worker national exam. We didn't do that for the LEP exam.
Right.
But
They're exposed to a different exam in that.
absolutely.
So
they're-
that's my point,
Yeah.
is that they wouldn't be exposed to the same exam for at least a 360-day period. Because they're not going to get the same exam twice. They're on the retake.
That's right. Yeah, you can't take the same version of the
Right.
exams
So that was my point. Is
sequence, yes.
because I'm just trying to rationalize because I have to explain some of this stuff sometimes.
I mean, it's
And I like
certainly,
knowing the thought process behind
it's certainly
it.
possible. We could chat with OPES and see if it's possible to get 3 different
And I
versions
don't
a
know
year.
that I'm hearing
Yeah.
that that's a need. I don't know that I would even move in that direction. I just wanted a really good, solid explanation of why the 180 days is being
Right.
adopted. And I don't have a problem at all
Okay.
with it. I just, in my mind, need to understand it
Right.
very clearly so that I can explain it if I have to.
Yeah.
And then the second question I have has to do with the accrediting agencies. The last item specify the accrediting agencies are acceptable for LEP. And I just wonder, because LEPs are, the accreditation is actually the school psych credential. There is no accreditation specific, I mean, it's not an LEP accreditation, it's a school psych accreditation. And some of that accreditation has to do with the Commission to the CTC, which may or may not, I think that's different from some of the other license types. And so just making sure that when we look at accreditation, that we're not trying to necessarily compare apples and oranges.
I don't think so.
No, the past reg did specify the regional accrediting agencies, so we're just making it consistent with what's in the statute now.
Okay.
But yes, obviously to become a school psychologist, you do have to do that, and to be an LEP, you have to have been a school psychologist.
Exactly.
So that's those things, those two things interact with each other, but not in any way that's going to, having this reg doesn't negatively impact or that.
I just wanted to make sure that we weren't asking them to comply with something that was outside of our normal educational path.
Yeah, it would not be any change
Okay.
to what we currently have. It's just updating it for consistency with statute.
Thank you.
You're welcome.
Any other board members' comments? Max, you good? No. Good. Public comments?
Hi, Kristen Raska from Campt. So my comment is pertaining to the minimum waiting period. So our only concern with the current language is that it's not really clear that it's perhaps like an act of God, and that it would open the door to some wiggle room for if there were some budgetary constraints. If that's an issue, certainly feel free to let us know, but our preference would be for some additional language clarifying as to, when that minimum would come into play.
It's adding the minimum 90 days and the minimum 120 days, right?
Between attempts.
Between the attempts, yeah.
Right.
So
we
retakes. So if I take it now,
Right.
I'm not successful, depending on the exam, it's 90 days or 120 days. And what that does is allow for the new version to be released. So I'm not taking the same one again.
I think though if I understand correctly, you're getting at, I said verbally that we wouldn't, it would be an event outside of the board's control that would make us go, okay, it's no longer 90 days, it's 120 days for the law and ethics exam, for example. I think maybe they're looking for us to specify that it's an event outside of the board's control, that where we would make it a longer waiting period. Is that?
I don't know of any situation where we have, quite frankly.
No, I think this Steve's not here, but this is something he had asked that we state that there are a minimum waiting period.
Right.
So I'm not sure. I'm not even sure. It hasn't been an issue, so maybe it's something we can take back to the office and talk.
Yeah, I think one of the concerns was some of the candidates may have taken an exam and then maybe a couple of months later a new version is released and they want to have that exam. But we're saying you have to wait at least X number of days. So I don't know, but I think Steve may have had another concern.
Yeah, so maybe it's something we take back and talk about.
Hmm?
And
So is this particularly just for LEP?
no,
Section, or is it like applied
Everybody.
to everybody?
it would be for any of our waiting periods. We would, right now, the law just says, depending on which one, 120 days is the waiting period. And it doesn't say minimum, maximum, any of that. It just says, boom.
Basically, boom,
Right.
that's the date,
Yeah.
right? You will be, and then by adding the minimum, then, it's okay that, that's, then, means that, it's okay that you wait 91 days.
Right.
Right. Yeah.
I know what that
If there were
is.
to be some sort of a, the exam got compromised and suddenly we had to implement a new exam and we had to stop or something, some people might be waiting longer than 90 days, So I think it's for that type of flexibility.
I think that makes
Yeah.
sense.
But, and then Camp is saying, well, maybe we need to be more specific about when, because I can see where you're coming from. Maybe a whole new, in 20 years, somebody else looks at this regulation and goes, oh, we can do, a year waiting period. You know what I mean?
Right.
So maybe it does need to be clear on in what circumstances.
Yeah. Okay, thank you, Kristen. Any other comments? Okay, so now how do we want to go from here? If you want to take back that, that minimum, that particular minimum, and we can still vote for the whole entire.
Right. Do you want to remove the reexamination section of the packet so they can look at that again and then recommend the rest of it go to the board?
Right. Yes.
Well, I mean, I guess it kind of comes down to if the committee feels like we need to really specify under what circumstances they may have to wait longer. My vantage point for a long time, I don't think it's necessary.
Well, isn't that, from what I recall earlier, this minimum is basically the time it takes for a new version to come out.
Yes, yes.
And that's
a
what it's kind
minimum.
of based on.
That's really what it's based on. It's the cycle of the release of the versions of the exam.
Right.
Which is every 90 for the law and ethics and 120 for but there have been,
So you're really,
there have been some outliers that have had some concerns with waiting that long,
Right.
right.
but they're outliers. By and large, first and foremost, it's the security of the exam, and you don't want it compromised.
Right. That puts public safety at
Right,
risk.
right.
And actually, you're dropping the minimum.
For the clinical, yeah. I
Right.
mean, but at a
So-
minimum is every 90 days for the law and ethics.
Right.
So,
And I think that's just, I don't know. From what I understand, it's just how long it literally takes. to
literally,
do
it takes, I mean, because we do
exam.
it all
Yes.
year round.
Yeah, it's a
and
cycle.
It's a
Right.
cycle.
It is a cycle, right?
Mhm.
Mhm.
So my question is how often that, that we make it 91 days, that we are not in compliance with the law?
Well, because the computer system is triggered to not let them in before 90 days.
Right.
So unless we go in there and substantially override it, I mean, that's what's going to happen.
Right.
I can fail the exam today, submit my retake out, and it's going to sit there until that 90th day rolls in, and then it'll kick over my eligibility to the testing vendor.
Right.
So,
Yeah. So the concern really is coming from clarifying, that language that you have to wait for minimum 90 days.
Right.
But it's not really about the technicality that, that there might be problems that, that it will take 91 day or 92 days for the new version to release.
yeah, the version's always released on time, but it may be that there might be a delay in transmission of eligibility. And then people are yelling, well, it's been 90 days. Well, sometimes computer glitches happen in eligibility, and so it's easy enough to fix. But if we're saying you're going to wait a minimum of 90 days, that's a reasonable expectation.
Right.
So, I don't know. I wish Steve was here because I'm not exactly sure what he was trying to address. I mean, I know I've had a couple of issues, but in the 10 years, I can probably look at point to two situations.
Right. We can, this is only the first step. And we will still, take the language, back up to the full board, for final approval. We're making a recommendation right now. And so I think, we can probably, just table that particular section, and just come back to the full board in less than a month, and we
Right.
can take a look at that. And maybe have Steve to,
Yes.
explore that a little further. And, and to really, look at, some of the concern from Campton.
Sure.
And then see if we can satisfy both, because I can see where both coming from. And I really don't anticipate that it will take the minimum, when we say minimum 90, it doesn't mean that it will take 180. It's really about when the 90 is not right on because of a technical issue, then, the board doesn't really want to, practice unlawfully. And yet, it's a good coverage. And from the licensee point of view, it's like you just open the gate, that's for no ending. Understandable. So I think we'll see how, where the real issue come from, and then be able to, to find a compromise. Okay? Very good. So in that sense, then the motion would be to remove, to table, actually to remove the minimum, the reexamination. Well, so is that remove the 1805.05?
Well, you can let it stay in,
Okay.
and we can still recommend it to the board, because there's going to be more discussion at the board level, and we'll have a chance to re-examine it at the board level and change language
Dan.
or approve this language at the board level. You can still recommend it
Right.
with the idea that, with Steve's input and further research or work with the staff, that you can still have this proposal moving forward to the
Yes.
board for their consideration. That doesn't mean they're going to adopt it like it is.
Right.
That
So
would-
leave it as a whole package.
Yeah.
And then
And
we
as a whole
come back,
package,
but
we'll come
research
back
that
next year.
particular piece.
Right.
Okay.
Okay, I like that motion. So I'll make that motion. Sure. Let's move it. So I need a second.
I'll second.
Betty second. And any other public comments? Okay, let's.
All righty, let's start with Max.
Yes.
Betty?
Yes.
Christina?
Yes.
Motion carries.
Thank you. And so then the next one is about the what?
We want to take a break. It's been a couple hours.
We have a
The next
couple
two
more
are really
reports.
quick
Oh,
updates.
reports.
Yeah, unless
Okay.
you want to,
No,
Okay.
if we're that fast,
Yeah, we're
We're
it
moving.
should be really fast, right?
I just looked at the whole page and went,
No.
Okay.
Yeah, so it's the status of the board sponsored, board supported, and board monitor legislation. So Roseanne, give us a report.
So for the legislative update, we're really kind of at an exciting time of year with legislation. The governor has until Sunday to sign or veto any bills on his desk. Most of the bills that the board considered, we already have answers on. The big one, SB 679, our license portability bill, was signed by the governor at the end of September. And so that will become law on January 1st. So I know everybody's happy about that. Our other bill, AB 630, which is the required notice to consumers about where to file a complaint with their therapist, that was also signed by the governor, as well as our omnibus bill, SB 786, that was signed last week as well. A few other ones of note, AB 1651, the bill permitting licensed educational psychologists to supervise associates and trainees in certain settings. That one was signed at the end of September as well, so that will be becoming law. And we're working on a fact sheet right now for that one. We're still waiting for answers on SB 163, SB 601, SB 10, which is the peer support specialist certification, and SB 425, which is the requiring health facilities to report allegations of sexual abuse. We're waiting for answers on those. We have a lot of two-year bills, but that's kind of where we're at right now.
Yeah, the passing of the LEP, the supervision law, is such a good example to show, the collaboration between the association with the board. I think, they work really, really hard, trying to, really promote, that, the possibility to open supervision, for the LEP. And it's wonderful. I'm so pleased that, the governor signed it, and I'm sure that Betty is, celebrating.
I know that that's a good, very nice. Yeah.
Yeah, and I also want to congratulate that, the license portability bill. It will be, the first in the nation. So, yeah, it really does. And so I'm really hoping that will become like the model bill for, for the rest of the country, to really promote the license portability. So it's really, really, wonderful and worthwhile to celebrate. So then I want to thank the good work for Roseanne
Thank you,
and,
Roseanne.
and Christy and Kim and Steve, and just really leading that, the committees and, and working with the stakeholders. So wonderful.
I had
Yeah.
one question before
Yes.
we close. At the risk of delaying, I just had a question, Roseanne, and you may not know the answer to this, and you don't need to track every bit of legislation out there, but SB 163 is now up for governor's signature, but it says, I noticed that you said that there were substantial changes made to it. Do you know what some of those key substantive changes were?
It was a lot of just, I don't think they were, it was enough that it would have to go back to the board for consideration. I think they put in some language about ensuring that our licensees followed the laws of the board, which isn't really substantial, but still needs to be considered. And then there was just some language changes in terms of parent participation and things like that. So nothing that I don't think would have changed the board's position. However, we would still, it was substantive enough that we couldn't assume the same position.
But it is on the governor's desk at this point with the new language.
Yes.
Okay. Thank you.
Thanks for the update. And I think the next update is the rulemaking proposal, and that will be Christy.
Thank you. So our AB 2138 regulations, which would modify our substantial relationship criteria, these regulations were noticed to the public on August 8th, 2019, and we had our hearing September 30th, but we did receive a comment from a stakeholder that, as Roseanne mentioned earlier, would be brought to the November board meeting for discussion. We also have our enforcement process regulations, which is modifying our uniform standards and disciplinary guidelines, and that was put on hold because of AB 2138. So we'll circle back to that at some point once those 2138 regs are finalized. A reg package on examination rescoring, application abandonment, and subsequent associate professional clinical counselor applications. It was submitted to OAL for final approval on July 22nd, but we had to withdraw it because there were some language changes identified that needed to be brought to the board for consideration. So that'll be coming to the board in November 2019. And we're still in our time frame, so it'll be simple enough to just refile it with OAL and have it through the process. So, and then our supervision regulations are under initial review with the Department of Consumer Affairs. We also have identified some changes that will have to come back to the board, and that is on the schedule for November 2019 as well. So that basically those were changes after AB 93 passed that will take it the next steps in strengthening our supervision regulations. So that's everything.
All right. Thank you. Any questions about the rulemaking updates? Public comments? Good, wonderful. Yeah, this is a very long process, but I'm so glad we're finally seeing some motions, some movements, which is good. Yeah. So, so the next is the public comments for items not on the agenda. Jan Lee.
Jan Lee Wong, NASW, I want to bring to this committee's attention some language in the OSHA. Everybody know what OSHA is? Okay. The OSHA Mental Health Services Plan for 2020 to 2025. In the innovations section, it mentioned that they want to look at some licenses to allow the last year of master's education internship to be counted in the required hours for licensure. Now, we know that's the case with MFTs, but it's not the case with LCSWs. The other vague innovation they mentioned was changing the scope of practice for licenses. I have no other information of what that is, but I'd be happy to speculate. My guess is that group that put that plan together thought that some of the scopes were too narrow or too specialized for the Mental Health Services Act, and they want to modify those scopes so that it's more accommodating to the Mental Health Services Act.
Jan Lee, you said OSHA, but I'm thinking maybe it's OSHPD?
Oh, I'm sorry, you're right.
Okay, I just wanted to be sure.
Yeah.
They both start with O, and they both have like S in it. So.
Yeah, okay, that makes sense. Thank you very much. Any other public comments for items not on the agenda?
Hi,
Hi.
Kristen Roscoe from CAMFT. So as you probably know, CAMFT will be working towards addressing some of the issues pertaining to AB5 next year, and we'll be looking to have a potential exemption for our membership. So obviously that's something that we'll be working on with our colleagues at the other associations. And so we just wanted to let you know that that is our intention, and we hope that should we be able to get some legislation in the future, that we would be able to have the support of the board in pursuing that exemption. And then a second one is just a general question of whether it has been discussed as to when there will be committee meetings held for the examination and licensing issue. My understanding is there is some discussion of having committee meetings regarding examination and licensing.
Yes, yeah. We've been a little under quorum.
Do we have an update of when? No.
We have to the chair will have to establish a committee. We're hoping for a few more members,
Perfect.
but we'll move on it.
All right, thank you.
Thank you very much. Any others? Suggestion? Okay, good. And the suggestions for future agenda items, and I want to officially just put that little education piece about the tiers of the codes, and I think that would be really helpful for the board and for licensees and everybody. So, yeah, thank you so much. And any other suggestions for future agenda items? Hey, we're good. All right. Wonderful meeting, everyone. So the time now is 10:37, and we're officially adjourned. Thank you very much, and see you in November.